that y'all had a good night last night, and y'all had a good morning, and I appreciate y'all being prompt today, being on time. We're about to start the case of the State versus Christopher Dontell. I do want to talk with you a little bit before the trial about expectations, things like that. But I want to tell you that this trial is probably going to be a little different than what you might expect. Many people don't have the chance to attend actual court sessions as you're doing now. You may think from watching television or movies or reading books that trials are always full of high drama, intense action, and riveting circumstances. And while all of these things may be true at times, this trial is not for entertainment. It is a fundamental part of our democracy. It's a search for the truth in an effort to make sure that justice is done between the parties before the court. Now, searching for the truth, making sure that justice is done, is often slow, deliberate, and sometimes very repetitive. The opposite of what you may have seen in television or in movies or read books. This courtroom is a place of honor, and it's dedicated to the protection and preservation of citizens' rights through what many have called the greatest justice system that has ever been created. The attorneys appearing before you are advocates for the cause that they represent. But first and foremost, they are officers of the court, sworn to uphold the integrity and fairness of our judicial system and to help you in the search for the truth. You should expect them to be professional, competent, and ethical in the representation of their client's interests. You are also expected to be professional, reasonable, and ethical. I thank you for accepting this important responsibility of jury service and for your contribution today to our justice system. I'm going to ask that our clerk swear you now as a jury.
Please stand and raise your right hand. Do you solemnly swear or affirm you will well and truly try the issues joined in this case and a true verdict rendered according to the law and evidence, so help you God? Thank you. You may be seated.
Thank you, Madam Clerk. What I'll now say is intended to serve as an introduction to the trial of this case. These remarks are not a charge of the law in this case. I'll instruct you on the law applicable to the case at the end of the trial before you retire to consider the verdict. This is merely an explanation of the procedure that we will follow in this trial so that you can better understand what may be happening. In this case, I am going to allow you to take notes. I'll have our bailiff provide you with notepads after our opening statements, but I will allow you to take notes as long as your note-taking does not in any way interfere with other jurors. Now, the defendant in this case is charged by an indictment filed in this court with the crime of murder, criminal conspiracy, conspiracy to commit kidnapping, and accessory after the fact, the elements of which will be explained to you later. The indictment is simply the charging document by which this case is brought into court, and it is not, in any sense, evidence of any of the allegations it contains. The defendant has specifically pled not guilty to all of the charges in this indictment. The state, therefore, has the burden of proving each of the elements of the indictment beyond a reasonable doubt. And it will be your duty, ladies and gentlemen, to decide whether the state has met that burden. Your purpose as jurors is to find and determine the facts. You are the sole judge of the facts. If at any time I make any comment regarding the facts, I'm going to ask you right now to disregard that. You will determine the facts from the testimony you hear and other evidence that's introduced into court. It is up to you, to determine the inferences which you feel may properly be drawn from the evidence that is presented. It is especially important that you perform your duty of determining the facts diligently, because ordinarily there is no way to correct an erroneous determination of the facts by a jury. On the other hand, the same law that makes you the judges of the facts makes me the judge of the law. The law as given by the court is the only law you may consider. You must accept and follow the law, even if you may disagree with it. I cannot tell you what the facts are, and you cannot disagree with me about what the law is or should be. Your job is to as you find them. And any other evidence that's been introduced. And after doing that, you will render your verdict. The verdict under the solemn oath that you just took as jurors. And I'll also tell you that you must base this case and your findings solely on the evidence presented in this court. That means that during this trial, you must not conduct any independent research about this case. The facts of the case, the evidence presented in this case, or the people or organizations involved in this case in any way. Please do not try to find out information from any source outside of the courtroom. In other words, you must not look at dictionaries or other reference material, search the internet, websites, blogs, Facebook, social media, anything like that. You may not use computers, telephones, cell phones, smartphones, tablets, the internet, or any other tools of technology with communication capabilities at any time while you are in the courtroom or during your deliberations. During your breaks for meals or overnight, if necessary, you can use those devices, but again, they are not to be used to in any way do any kind of research in regards to this case. Now, in a few minutes, you're going to hear an opening statement by the state. The state's opening statement is simply an introduction into what they believe they will be able to show you during the trial. What the state and what the solicitor tells you during their introduction or their opening statement is not evidence. It is simply what they believe that they will show you during the trial. After the state or after the solicitor gives their opening statement, the defense will then have a chance to make their own opening statement. And again, I tell you that the opening statement made by the defense or the solicitor is not evidence. It is simply what they believe they will be able to show you or not show you in trial. With all that being said, I appreciate you being here. I thank you for your willingness to serve. This will be a somewhat long trial, and I understand that sometimes your minds can wander, but I'm going to ask you to try your best to stay in the task. Mr. Foreman, as the foreman, it is your duty to advise me of any issues you may have in the jury room. If there's any questions, if there's any emergencies, I'm going to ask that you immediately tell them about it. We're going to go ahead and begin this trial. And again, I thank you for your service. Sure. Yes, sir. Recess. After the recess, we'll hear opening statements. Okay? Again, I'll ask you to retire to the jury room. As I've told you before, do not discuss anything that you've heard so far. We'll be back with you shortly. Thank you.
courtroom that Dontell wants to plead guilty. So we're still on a break there inside that courtroom. He has also asked to be sentenced today. So a lot of breaking news, and we will bring you all the details as soon as we get more of them. So now let's turn to Massachusetts. Always big trials there in Massachusetts, where a trial date has now been set for the husband who is accused of killing and dismembering his wife. So this is going to be another good trial that we're going to start watching here on Court TV. Anna Walsh was last seen New Year's Day 2023. Nearly 2 years later, her body has never been found. Anna's husband, Brian, he is charged with her murder. Key evidence in this case centers around the defendant's online searches the day that Anna disappeared. Investigators say that Walsh searched for the best ways to dispose of a body. And what's the best tool for dismemberment? His trial does begin in October of next year. Court TV crime and justice correspondent Matt Johnson has a look at this case against Walsh.
No comment from Brian Walsh after he was charged with the murder of his wife, Anna Walsh, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walsh was awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell.
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., hacksaw best tool to dismember. At 1:10 p.m., can he be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walsh came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes.
On January 3rd, prosecutors say Walsh drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walsh drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. Then on January 6th and 7th, police searched the Walsh property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walsh was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walsh, as well as disinterring of a body.
A hearing was held in the Brian Walsh case yesterday. So let's bring you that hearing now that took place in Massachusetts.
Good afternoon to lawyers and good afternoon to the defendant. So happy to see everyone, and I'm going to go through what I have on my agenda, and then I'll address with you whatever, if I can, address with you whatever questions you have. On my agenda today is to talk about the pending discovery disputes, see if we can make some forward progress on that today, either today in the hearing or if not, ruling in the near future. I want to discuss the scheduling order and where I see this case going in terms of progressing forward and discuss your joint motion that you submitted last week, and a preview for that. I guess I don't see this case going into 2026 for a trial. I think it should be tried in 2025. I'm certainly going to do my part to make sure that it keeps on track to get us there. And that's due to, in large part, the age of the case and its respective complexity, or not, and the range of cases like it. So I think that it's reasonable to assume that a case such as this one will be tried within 2 years of indictment. On the present schedule, or looking there that you suggested, I think it's coming closer to the 3-year mark, and I think that's a little unnecessary. And nothing gets better with time. People's memories don't get any better, and the case isn't going to get any stronger. People's memories fade over time, and so I've been interested in making sure the case gets tried as efficiently as is possible, respecting the numerous issues that have to be addressed. So we'll talk about that. And then I think attenuate to the motions that have been filed, we're going to need another date, or perhaps need another date on the Rule 17 motions, which I appreciate the defense filed come up, I assume, based on your earlier pleadings, and third parties may be filing objections to those, so we'll get that on the calendar. With regard to the calendar, I'm happy to come down here today. As you know, I have been specially assigned. I want you to know when we're picking dates for future things that it's highly likely you're going to be traveling. I'll try to travel here when I can, because I know that this is where it is. But you should also build in the expectation that you may be traveling, and the travel in the next 3 months is going to be to Middlesex County, because that's where I'm going to be assigned for the first quarter, and deliberately not far from here, recognizing that I probably would be seeing you a bit between now and whenever we get the case ready for tee up for trial. So let me say that, just so that you sort of have an idea of what my knowledge base is, and I've gone back and tried to listen to a number of the hearings on the case, most notably, I guess, and most importantly, your last hearing before Judge Cannoni, when this issue with regard to, I think as Attorney Tipton said, it was an exhaustive or extensive discovery request came up, and you all thought that you could make some headway, and you did make some headway, although there's some disputes that still linger. At that time, so I listened to that last hearing. I also went back and listened to a hearing on June 24th, in which the parties informed the court that the trial date was too tentative at that point, at least 6 months ago anyway. I have before me now what are the first round of discovery disputes. Those were docketed, just for the record, and as paper number 18, the defendant's motion for discovery of documents related to the district attorney and law enforcement. That then gets updated by your second motion, which I got to be filed on Friday. That's paper number 32. I've gone through those. I've gone through the Commonwealth's oppositions to those. And then also, I received on Friday paper number 31, which is, I'll call it the federal investigation motion, and the Commonwealth's opposition to that, which I just briefly, I got it just as I was coming down the stairways, and I've read it, but I haven't given it much thought. The first thing I wrote before I got your opposition was do a TUI request. And so I see that at the end of that, that's exactly what we're doing. We'll get to that in a minute. So I've read all the pleadings. I have looked at some of the law that I want to look at. There's one thing that I didn't get a chance to look at this morning, but I'll hear from you. And perhaps the best way to do it is to just go item by item and identify. I think it pretty clearly now identifies where there's a variance. If you wish to be heard on any of the orally, I'll certainly give you the opportunity to do that now. If you want to rest on the papers, that's fine too. I may have questions as we go through them. But why don't we all just turn to paper number 32 and go through those now.
introduction?
Sure.
I think by and large, I'll just rely on this plea that was filed after the Commonwealth.
All right, that was that hearing from Massachusetts that was yesterday, and we wanted to replay that for our viewers. Meanwhile, here in Conway, South Carolina, we are continuing to follow developments in this case here, where the defendant, Christopher Dontell, has said that he wants to plead guilty. We'll have all the latest when we come back.
Bounce elevates and celebrates the achievements of HBCUs all year long.
From the classroom to the field, we are making history.
Bounce HBCU Yearbook.
If you think you can report on American politics by just staying in Washington, D.C., you're doing it wrong. Do you hope his visit to the picket line changes some policies? I make it a priority to go to places that aren't spoken about on national news and bring their perspective to my reporting. Are you going to vote? This country is so diverse. And if you thought 2024 was busy, buckle up. Joe St. George, Scripps News, Washington.
For live reports, breaking news, and headlines from across the country, stream Scripps News.
You budget, you pay bills.
Yet somehow, women like you, like me,
Are 80% more likely than men to live in poverty in retirement.
So here's what we're going to do now. We're going to save ourselves by setting a goal to save 2% more of our income for our retirement.
Why do?
1% honors you, and 1% honors
.com.
Welcome back to Court TV Live. I'm Julia Janae. Thank you so much for following along with us this afternoon. We have been in several courtrooms today. A lot happening here at Court TV. Our legal correspondent Kelly Craft is going back into the courtroom there in South Carolina, where we are following that breaking news that the defendant in the coroner affair murder trial is deciding to plead out the case. This after the jury had been brought in and we were preparing to cover opening statements. So we will keep you posted on what happens in that courtroom. For now, we are turning our attention to Massachusetts, where a man who's accused of killing his missing wife was back in court yesterday for an important discovery hearing. Brian Walsh is charged with first-degree murder in the presumed death of his wife, Anna. She was last seen on January 1st of 2023 having dinner with her husband and a friend. Investigators say Brian killed Anna that night and spent the following days concealing the crime, including making a fake ransom note. Anna's body has never been found, and her husband, Brian Walsh, was last in court in October, where his lawyers raised questions about the integrity of the Norfolk County's investigation. You'll remember this is the same county that handled the Karen Reed investigation, where there were a lot of questions about ethics and how things were handled. That October hearing for Walsh was continued until yesterday in order to give these parties time to review the large amount of discovery. That includes cell phone data from Trooper Michael Proctor, another name you'll remember. He was the lead investigator in the Reed case. Let's go into court now. We're listening again to that discovery hearing that eventually is going to mention Trooper Proctor.
After the Commonwealth and the defense sat down on a number of occasions and worked through this. By and large, Judge, what we're asking, just turning to page 2, paragraph 1, subparagraph A.
Yes.
We continue to ask for disclosure. I understand the reality of this is that they've engaged an attorney who I am familiar with professionally, and like I say in our motion, we don't object to Attorney Sack being assigned to review. So we have no objection to him, and I'm not familiar with Jim Carney, but I have no objection to Jim Carney. It's just that we believe, based on the existing case law and the citations that I've provided in the memorandum, that defense counsel is in the best position to assess the exculpatory nature and the utility of this information, whether it impacts bias, credibility, or the Bowden defense of the conduct of the investigation. And for those reasons, and I'll leave it at that, we ask that this material that the Commonwealth declines to turn over be turned over. Other than that, that's all I'd have to say on that particular issue.
So, Your Honor, I can tell you that not only did we retain Attorney Sack, and he's received the download of the phone, I am also going through the phone, through all of the emails and all the text messages and anything that could be a statement to try and find Brady material. But I'm also focusing in on Rule 14 statements, and I feel it's my duty under Graham and McFarland to go through this myself and find anything that could be potential bias, but also statements, and I'm doing that. I've focused in on all
I'm
of
happy
it.
to hear that, because you'll find that I try to be as transparent as I can,
Yes,
to both sides. And when I read this, I don't know Attorney Sachs, and I don't know the computer person either, but this is interesting. Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it. But I have never seen special ADAs, special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And my initial response, honestly, was, I don't think they can do that. I don't think they can delegate that responsibility to an attorney. But it sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check.
Yes, Your Honor.
For the consultant attorney.
That's the purpose of Attorney Sack, is not to outsource it, but to double check what the Commonwealth has done.
Okay.
And he's doing it independently.
All right, that's always good to have another set of eyes, I suppose.
Yes, Your Honor.
All right, anything else that you want to talk about with regard to this beyond what's in the papers?
Not beyond what's in the papers, Your Honor. We pointed out that there's sensitive material in there about ongoing investigations. Turn over the phone wholesale would be problematic. It could jeopardize ongoing investigations, and as a result, that's one of the key issues of why we can't turn over the phone wholesale.
By the way, what I'm probably going to do is, following this hearing, is I'm going to give you an omnibus order on discovery. And I'm going to follow your sort of how you set up the issues because it makes sense. And so I'll just go 1A, B, C. It makes sense, and I'll probably be doing that more quickly than I thought it was going to be because my trial was supposed to start tomorrow, just tangentially. So I'll have an opportunity to look at this while it's fresh in my mind. I'll get something out to you. I will tell you that preliminary view on this is that it's the Commonwealth's obligation, and that nothing that has happened or that I've read so far turns that on its head. And the idea here that I understand that the defense has a very unique perspective on every piece of evidence that is just a different view than a prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information that I know. But that's just my preliminary view, and I want to give some more thought to the arguments that have been made. All right?
May I proceed?
Yes, please.
With regards to paragraph number 2, the request regarding the 3074 pages, I will defer to Attorney Kelly Porges, who at the time when we finish this motion, she will be arguing the motion that addresses that request, I think.
Okay, that's the motion, paper number 31.
Yes.
I will defer on that one.
We don't need to touch upon paragraph 3. We're waiting for a production of those letters. Paragraph 4, we don't need to address because we're withdrawing that at this time.
Right.
Regarding paragraph 6 is really subsumed in Rule 17 that we'll deal with it.
5 is not an issue either, right?
5 is not an issue. I'm sorry. And once again, paragraph 7, that's assumed in the Rule 17 request, I do believe. Number 8, we all agree, at least the Commonwealth, we agree that that's captured in paragraph number 5, the request 5, and we don't need to deal with that. Moving ahead through now to request number 14. What we're trying to do is say that the Commonwealth needs to produce this unless it can make a sufficient showing of what it characterizes as the basis of its argument, that what we're asking for implicates the work product rule. And where I would agree that if the work product rule under 14A5 is in fact implicated, I understand that they would have grounds to say they can't disclose it. But I find it hard to believe that what we're asking for, that the entire universe is captured as work product. And so for those reasons, we ask that that request be allowed in so much as what we've asked for, that they
Why isn't a good initial step to just say, have them, you know, we commonly see this in civil litigation, but go through, and it's perfectly appropriate for criminal litigation as well, to go through and say, this is the basis for the work, this is, you know, the privilege law, and at least give the defense then the universe of what the responsive documents are, and if it is the Commonwealth's position that they're covered by work product privilege, there'll be enough information that you can make some, everybody can make some preliminary assessments. That long.
Reaching out to, we've also produced any and all notes and reports from the crime lab. That aren't being produced would be mine. And those strategy, theories, thoughts on the case. And so at this point in time, those would be worked on.
All right. Do you have any objection to putting those All I'm asking you is from the date